Good afternoon, everybody. My name is Mark Carter. I'm a professor here at the college, and I'm also the chair of the Speakers Committee. And I'd like to welcome you to this event this afternoon, and welcome to those who are with us on live stream. And we're delighted to see so many of you join us for this Cronkite Memorial Lecture. It's the first lecture event of the season. And as we gather here today, we acknowledge that we're on Treaty 6 territory, the homeland of the Métis, and we pay our respects to the First Nations and Métis ancestors of this place and reaffirm our relationship with one another. On behalf of the college, I'd like to express our gratitude to McKercher LLP. The firm's generous sponsorship makes it possible for our college to host these lectures. And we strive to bring you lectures that are enriching and thought-provoking, not only for our law students, but for the broader community. And I'm pleased to see so many law students, faculty members, and people from the broader community with us today who aren't involved in legal studies or work. The Cronkite Memorial Lecture was inaugurated in November 1978 to honor the longtime dean here, Frederick Clinton Cronkite, KC. He was dean from 1929 to 1961. And in keeping with Dean Cronkite's primary interest in public law, the lectures emphasize that area, as we are doing today with a theme of constitutional law. The first Cronkite lecture was delivered by the Honorable Emmett Hall, esteemed graduate of this college from 1919, and Supreme Court Justice. Cronkite lectures also been delivered by Judge Barry Strayer, who was born in Moose Jaw, graduated from the University of Saskatchewan, was a professor here as well, and was one of the drafters of the charter when he was with the Federal Justice Department. Other lectures have included Justice Rosalie Abella of the Supreme Court of Canada, the Honorable Justice Walter Tarnopolsky, also a university graduate from here and a pioneer in the area of human rights and civil liberties. Our guest speaker today is Adam Goldenberg, whose lecture will explore a topical and fascinating question that's posed in Saskatchewan. The title of Mr. Goldenberg's speech is Notwithstanding the Courts, Populism, and the Courts in a Constitutional Democracy. Mr. Goldenberg is a partner at McCarthy Tétrault, LLP in Toronto, represents many Canadian leading companies, as well as individuals and public interest organizations in commercial and regulatory constitutional litigation. He's appeared in over 24 appeals to the Supreme Court of Canada and has been counsel in the courts across Canada, as well as in the federal courts and private arbitration. Mr. Goldenberg regularly acts pro bono for individuals and public interest organizations in matters affecting the LGBTQ2S+ community. He's lead counsel to UR Pride, University of Regina Pride Center for Sexuality and Gender Diversity in its ongoing constitutional challenge to Saskatchewan's law on the use of gender-diverse students' chosen names and pronouns. And I'll just say before handing it over to Mr. Goldenberg that it's likely that the comments will go close to 1, and I know some of you have classes, so if you need to sneak out a little bit early, you're forgiven for that. And Mr. Goldenberg knows about that. So if I'm going to hand it over to Adam Goldenberg, everybody, please join me.
Thank you very much for that kind introduction, Professor Carter, and thank you all for being here. As a constitutional and public lawyer, it's a huge honor to be invited to deliver the Cronkite Memorial Lecture. Thank you all for allowing me to be part of this college's long tradition of advancing the conversation about public law in this country. No one embodied that tradition more than Dean F.C. Cronkite, our namesake today. Frederick Clinton Cronkite was a giant of the public law bar in this country. After receiving his undergraduate education at the University of New Brunswick, his home province, he took a law degree at Harvard and then returned home to New Brunswick to practice. He lasted 5 years at the bar before he was lured west to this college in 1924, and as you heard from Professor Carter, 5 years later he was dean, a position that he then held for 32 years, which is slightly longer than my lecture will be today. In the late 1930s, Dean Cronkite was among the drafters of Saskatchewan's submissions to the Royal Commission on Dominion-Provincial Relations, which was known colloquially as the Royal-Sirois Commission. Saskatchewan's submissions are where we find the origins of what is now the Federal Equalization Program, which has been enshrined in our Constitution since 1982. And it's because of this and his many other contributions to the governance of our country that we gather today in Dean Cronkite's honor. As you heard from Professor Carter, Justice Emmett Hall of the Supreme Court of Canada was the first Cronkite lecturer in 1978, and thus began an impressive run of Cronkite lecturers that continued unbroken until approximately 5 minutes ago. In my turn at this lectern, my aim is to explore an urgent and consequential development in Canadian constitutional law: the transformation of Section 33 of the Canadian Charter of Rights and Freedoms, the Notwithstanding Clause, from a subject of taboo to one of temptation in the politics of our country, and of this province in particular. My starting point is a question that has gnawed at me, especially as the UR Pride case has worked its way through the Saskatchewan courts. Why have politicians, here and elsewhere, been able to resort to Section 33 and its extraordinary grant of legislative power, even preemptively, without being deterred by the political cost of doing so? Why has support from the public for constitutional rights and their protection through the courts, which was supposed to be the thing that imbued the Notwithstanding Clause with political radioactivity, apparently failed to do this? My answer, of which I hope to persuade at least some of you this afternoon, is that a particularly pernicious species of anti-elite populism has begun to corrode public confidence in our courts. This has made it less daunting for politicians to use the Notwithstanding Clause to deny courts the power to prevent laws from operating. This is a problem because, thanks in large measure to the contribution of lawyers from Saskatchewan, indeed from this very college, court-based rights adjudication is a central feature of Canada's modern constitutional democracy, especially our mechanisms for protecting minorities. And those mechanisms will fail if invoking the Notwithstanding Clause becomes anything close to routine. Today, I hope to convince at least some of you that the corrosion of confidence in the courts has not happened spontaneously. It is instead a product of political strategy, particularly on the political right. For that reason, it is reversible. Since political strategy is ultimately accountable to public opinion, it is within our power, the power of the public, to change it. Before I go any further, however, let me offer 3 disclaimers. First, I'm a lawyer in private practice and I work at a national law firm, as you heard from Professor Carter. Nothing that I say today should be taken to represent the views of any of my colleagues or any of our clients. I'm here in my personal capacity and I'm speaking on my own behalf only. Second, and for the avoidance of any doubt, I am not speaking here today for UR Pride Center for Sexuality and Gender Diversity, the organization that I have the honor of representing in the UR Pride case. Nor am I speaking for any of the other 2S LGBTQI+ organizations that I represent in ongoing and anticipated litigation, including the litigation concerning Saskatchewan's use of the Notwithstanding Clause. A week from today, my colleagues and I, including Sean Sinclair, my co-counsel, who's here in the room today, will be in the Court of Appeal in Regina. And if you've joined us today for a preview of our arguments in the appeal, I'm afraid you will be disappointed. I subscribe to the perhaps antiquated view that a barrister should reserve their submissions for the courtroom, and I intend to abide by that policy today. So I'm not going to address the question that is before the Court of Appeal in the UR Pride case, namely, whether the invocation of the Notwithstanding Clause ousts the jurisdiction of the superior courts to grant declaratory relief. My argument today relates to the politics that have given rise to that jurisprudential question. I'll consider why politicians feel emboldened to seek to exclude the courts, not whether the Notwithstanding Clause actually empowers them to do so. My third and final disclaimer is that I'm not here to prognosticate. To the extent that my comments today pertain to the current Saskatchewan government's use of the Notwithstanding Clause, my premise is that the members of that government believed they could do this without losing their jobs. That does not mean they will be proven correct in about 6 weeks from now. Personally, and this is as far as I intend to venture into electoral politics today, I hope you'll leave this lecture feeling empowered to impose a political cost at the polls, not only for the gender-diverse young people whose lives this government has cynically and gratuitously made more difficult, but also for our country and this province's commitment to constitutional rights and to the rule of law. Now, on with the lecture. The current government's preemptive use of the Notwithstanding Clause is a marked departure from this province's contributions to Canadian public law. I would, in fact, go further. It's a betrayal of Saskatchewan's history as a pioneer in the protection of minority rights in Canada. It was in Saskatchewan in 1933 that the Cooperative Commonwealth Federation, the predecessor of today's New Democratic Party, adopted the Regina Manifesto, which called for legal reforms to protect the freedom of expression and equality before the law. It was in Saskatchewan in 1947 that the government of Premier T.C. Douglas introduced and the Legislative Assembly enacted the Saskatchewan Bill of Rights Act, the first such legislation in Canada, indeed the world. And it was another great Saskatchewanian, the Right Honourable John G. Diefenbaker, who in 1960 gave Canada our federal Bill of Rights. Prime Minister Diefenbaker, a member of this law school's class of 1919, considered the Canadian Bill of Rights to be among his most important achievements. This sworn enemy of discrimination, as he described himself, began drafting a Bill of Rights as a young lawyer when he devoted part of his practice to advocacy for minority and civil rights, including the right to equality. Diefenbaker advanced these commitments in politics through his unsuccessful runs for office in the 1920s and 30s, his quixotic leadership of the Saskatchewan Conservative Party from 1936 until 1940. He led the party to a 0 seats result in a provincial election, and then as a member of Parliament and Prime Minister. It's easy today to understate the significance of the Bill of Rights. It's not a constitutional instrument, as the law students in this room will know. It applies only to federal laws. Without doubt, it has been eclipsed by the Canadian Charter of Rights and Freedoms, to which we will turn shortly. But the Bill of Rights also represented, and I say still represents, a major milestone in the development of the Canadian regime of rights protection. Never before had federal lawmakers committed to a set of civil and political entitlements that represent our whole country's constitutional tradition. The right not to be deprived of life, liberty, or security of the person, except by due process of law. The right to equality before the law. The freedoms of religion, speech, the press, assembly, association. Each of these rights and freedoms had long been part of Canadian legal tradition, but only at the sufferance of parliamentary majorities. Now, for the first time, and thanks to a Conservative from Saskatchewan, our elected representatives had put our most fundamental commitments in writing, in one place, with directions to the courts on how our enumerated rights should apply to other federal enactments. We were to be governed not merely by a majoritarian edict, but instead by legislatures and courts in accordance with rights enshrined in law. In this way, the Bill of Rights was transformative. The Bill of Rights also represented the continuation of an important feature of Canada's system of constitutional supremacy, namely, the role of courts in implementing commitments that are anterior to duly enacted legislation. What do I mean by this? For as long as our country has existed, courts and judges have been empowered to say no to elected politicians, We have had a written constitution in this country that has constrained legislative power since Confederation. It used to be called the British North America Act. The Bill of Rights did not alter this aspect of the judicial role, nor did it add to the judicial role at the constitutional level. It did, however, give courts the power to render duly enacted, constitutionally valid legislation inoperative if it was incompatible with the rights and freedoms sanctified in the Bill of Rights. This broke important new ground in Canada, ground that lawyers like me are still tilling today. In 1969, in a case called Dry Bones, with which all the 1Ls in the room will soon be familiar, a majority of the Supreme Court of Canada, including John Diefenbaker's law school classmate, Justice Emmett Hall, determined that Section 94 sub B of the Indian Act, which made it an offense for an Indian to be intoxicated off reserve, offended the right to equality in Section 1B of the Bill of Rights. If you can believe it, this was a controversial conclusion at the time. But the court then did something that was even more controversial, and that it had never done before. It declared the law to be inoperative. It could not be in effect. Parliament had duly enacted the law, Section 94B of the Indian Act. It was constitutionally valid, and yet, according to the Supreme Court, it could not operate. Why? Because according to a majority of the judges, it ran afoul of the Bill of Rights, Diefenbaker's Bill of Rights. This was a major development in Canadian law. By empowering courts to render laws inoperative on rights grounds, the Bill of Rights shifted authority from legislators to judges for interpreting and applying our collective commitments to civil liberties. Diefenbaker himself saw this as a purpose of the legislation that he had proposed. He told Parliament that under his Bill of Rights, and I quote, "Wherever there is a violation of any of those declarations or freedoms, the statute in question is to that extent non-operative and was never intended to be operative." In other words, if a court concluded that a law offended the Bill of Rights, the court could, indeed it had to, declare the law to be inoperative. And that's precisely what the Supreme Court of Canada did in Dry Bones. Alongside this grant of judicial power, the Bill of Rights also introduced a form of legislative power into Canadian law, a grant of power that allows Parliament to render laws operative even if they deny, abrogate, or infringe rights or freedoms that are recognized in the Bill of Rights. We find this legislative power in Section 2 of the Bill of Rights, which contains a non obstante provision, also known as a notwithstanding clause. Section 2 of the Bill of Rights provides that a federal law shall be construed and applied so as not to abridge rights or freedoms unless, and I'm quoting here, it is expressly declared by an act of the Parliament of Canada that it shall operate notwithstanding the Canadian Bill of Rights. If this language sounds familiar, that's no coincidence. The notwithstanding clause in the Canadian Bill of Rights is the predecessor to the notwithstanding clause in Section 33 of the Canadian Charter of Rights and Freedoms. And as Professor Carter observed in a 2019 article in the Saskatchewan Law Review, the latter was derived directly from the former. Because here too there is a Saskatchewan connection to which Professor Carter has already alluded. One of the drafters of the Bill of Rights was Elmer Dreger, assistant to the Deputy Minister of Justice, a 1934 graduate of this college, and famously the proponent of the modern principle of statutory interpretation. One of the drafters of the Charter, meanwhile, was Assistant Deputy Minister of Justice Barry Strayer, later a judge and a 1955 graduate of this college. Next week, Sean and I and our colleagues will argue about their handiwork. One of the questions before the Court of Appeal is, what are the implications of the words "shall operate notwithstanding" in Section 33 of the Charter of Rights and Freedoms? Those very words originate in Section 2 of the Bill of Rights. They also appear in the reasons of the Chief Justice of Saskatchewan, the same Emmett Hall, in a 1962 case called, and I'm about to butcher the name, Shumiatcher versus Saskatchewan Attorney General. Did I get it right, Professor Carter? Thank you. I practiced for hours with that one name. There, immediately after referring to the notwithstanding clause in Section 2 of the Bill of Rights, Chief Justice Hall said this: "The courts must be vigilant in seeing that the provisions of the Canadian Bill of Rights are not breached, ignored, or whittled away." this role for the courts in rights adjudication, which Chief Justice Hall recognized in Shumiacher and which the Supreme Court reaffirmed in Drybones, is the Bill of Rights' most transformative contribution to Canadian law, and by way of the Charter, to Canada's constitutional democracy. It is a contribution for which Saskatchewan, and this college in particular, should be proud. And as we shall see, it's under threat today like never before. As Professor Carter notes in his article, one of the individuals most responsible for the Notwithstanding Clause in the Bill of Rights was Professor Frank Scott of McGill University. Professor Scott was a fierce advocate of entrenched rights and freedoms. He was a co-founder of the NDP, and he was a mentor to Pierre Elliott Trudeau. Professor Scott figured that since a future parliament might otherwise just repeal the Bill of Rights, it was ordinary legislation after all, and thereby disappear the rights and freedoms that are guaranteed in it, it was better to offer legislators, parliamentarians, another option, the power to declare that a law would operate notwithstanding those rights and freedoms. But, and I'm quoting Professor Carter here, who in turn was quoting the work of Christopher McLennan, it was hoped that future governments would be hesitant to announce their intention to infringe upon the human rights of Canadians. Again, the hope was future governments would be hesitant to announce their intention to infringe upon the human rights of Canadians. That same hope was shared by the provincial leaders who insisted on transposing the Notwithstanding Clause from the Bill of Rights into the Canadian Charter of Rights and Freedoms in 1982. Here, again, we see Saskatchewan's fingerprints. The Notwithstanding Clause seems to have first appeared in a draft of the Charter that was prepared by the government of this province in July 1980. By August of that year, the non obstante provision had become a consistent feature of compromise proposals for the Charter. Premier Alan Blakeney of Saskatchewan later defended the Charter's Notwithstanding Clause as a means of protecting economic or social rights after the courts have upheld individual rights at the expense of the collective. Notice that Blakeney's justification, though, presupposes a substantive disagreement between courts and legislatures. Such a disagreement can only arise after a court has decided a charter case on its merits. Otherwise, there's nothing substantive with which to disagree. That same assumption bears on the views of the other provincial premier who most prominently championed the Notwithstanding Clause in the Charter, Premier Peter Lougheed of Alberta. In a lecture in 1991, Lougheed characterized Section 33 as a sort of safety valve, which gives politicians a non-destructive means within the ordinary legislative process of responding to judicial decisions with which they disagree. Lougheed's rationale, like Alan Blakeney's, cannot justify the preemptive use of the Notwithstanding Clause, because when politicians resort to the Notwithstanding Clause before a court has considered whether a law unreasonably limits charter rights, the politicians aren't acting in opposition to a particular judicial decision. They're acting against the judiciary itself, a point to which I shall return. Pierre Trudeau hated the Notwithstanding Clause. He didn't want it in the Charter. He relented only on the condition that the clause would only protect the operation of a law for 5 years at a time. And here I'm indebted to Tom Axworthy, who was Trudeau's principal secretary at the time, and his memoir of the Charter negotiations, which is published in Peter Byro's recent book on the Notwithstanding Clause, is an indispensable resource for this history. Trudeau was reassured by his officials that the Notwithstanding Clause wouldn't be abused because of the political cost of doing so. This was the conventional wisdom in the early 1980s and for decades thereafter, and as you heard, it goes back to the assumptions that were made by Professor Scott and others at the time of drafting the Bill of Rights. The expectation was that legislatures would not abuse their power under the Notwithstanding Clause. Indeed, they would be unlikely to invoke it ever at all because they would have to pay too high a price at the polls. And there was evidence in support of this expectation. The Notwithstanding Clause in the Bill of Rights had only been used once, and similar provisions in provincial bills of rights, other than in Quebec, had never been used at all. Writing in the Queen's Law Journal in 1982, Ontario's Attorney General, the late Roy McMurtry, argued that the political cost of invoking the Notwithstanding Clause was the best safeguard against its misuse. Justice Minister Jean Chrétien, in presenting the proposed Constitution to the House of Commons, emphasized that it would be, in his words, politically very difficult to invoke the Notwithstanding Clause without very good reason. In that speech, Chrétien quoted the late Alan Borovoy, the General Counsel of the Canadian Civil Liberties Association, who had agreed that public opinion would be a reasonable safeguard against the use of the Notwithstanding Clause. So had the Chief Commissioner of the Canadian Human Rights Commission, who went as far as to predict that the clause would prove to be a dead letter, like the federal cabinet's power to disallow provincial laws under the 1867 Constitution, the disallowance power. Conservative parliamentarians agreed. Jake Epp, a Manitoba member of Parliament, argued that the political cost of using the Notwithstanding Clause would ensure that only very important legislation with broad public support would attract its use. Ray Natition shared this view too, and Natition was, as many of you will know, the MP for Saskatoon West, later the Minister of Justice, and eventually the Governor General. Behind the assurance that the Notwithstanding Clause would scarcely be used, that it might even prove to be as dormant as the disallowance power, were a number of assumptions about Canadians and about our attitudes towards rights and our attitudes towards the courts. And it's these assumptions that recent events have thrown into question. The drafters of the Charter, like the drafters of the Bill of Rights, took for granted that Canadians cared about the rights and freedoms that these instruments guarantee. They assumed, rightly in my view, that Canadians would not lightly tolerate legislative interference with our rights and freedoms, despite a statutory and now a constitutional provision that authorizes such interference. And baked into this assumption is another assumption, that even if we might disagree with particular decisions or lines of case law, Canadians respect the role of courts in rights adjudication. That role has been part of Canadian law since Diefenbaker's Bill of Rights. Legislators who sought to invoke the Notwithstanding Clause after the courts had pronounced on a question of charter rights would have to overcome not only the rights themselves, but also a judicial decision or decisions affirming them. And this, most everyone believed, was a sufficiently high political bar that the Notwithstanding Clause would rarely, if ever, be cleared, be used. For a very long time, these assumptions proved correct. Outside of Quebec, which never signed on to the Charter and where the use of the Notwithstanding Clause is bound up with national identity in a way that it is not elsewhere, the Notwithstanding Clause has only ever been used a handful of times. And with very few exceptions outside Quebec, it has been used responsively rather than preemptively. That is, after a court has struck down legislation as unconstitutional, not before the courts have had the opportunity to do so. I pause here to note that a number of outstanding scholars, including Professor Dwight Newman of this faculty, who's with us today, and Professor Gerard Kennedy of the University of Alberta, have offered thoughtful arguments for the Notwithstanding Clause as a means of enhancing rather than detracting from the protection of rights under our constitutional framework. To their claims, I plead a lecturer's favorite defense that I lack sufficient time to give them the careful attention that they deserve, except to say this. Even if, in some circumstances, the Notwithstanding Clause may advance the noble aim of involving legislators in the shared task of constitutional interpretation, as Professor Newman would contend, it cannot do this when it is used preemptively. Professor Newman has written that the real meaning of a use of the Notwithstanding Clause is an expression of a difference on the interpretation of rights. But there is no difference on the interpretation of rights when the courts have not yet offered an interpretation of the rights on a constitutional question that the legislature has engaged with by using the Notwithstanding Clause. When the clause is used preemptively, it doesn't express principled disagreement with the courts on a matter of constitutional interpretation. It signals political disinterest in the court's role. The preemptive use of the Notwithstanding Clause preempts the outcome of the judicial process. That's why we call it preemptive. It's not a thoughtful response to a court's decision. It's a political reaction to the prospect of the courts making a decision. It is, in other words, opposed to judges, not to a particular judgment. And this is one reason why using the notwithstanding clause was supposed to be politically costly, and why it is so concerning that it is not. Today, there is just one province outside of Quebec in which legislation is operative because it invokes the notwithstanding clause preemptively. Only one province, and that province is Saskatchewan. The province of Douglas, Diefenbaker, and Dreger, of Hall, Strayer, and Blakeney. And the legislation is Section 197.4 of the Education Act of 1995, which operates notwithstanding the charter provisions that guarantee the equality and security of the person of a small and vulnerable minority of Saskatchewan students, namely gender-diverse young people. This province, as much or more than any other, deserves credit for the legislative and constitutional protection of civil liberties in this country. And yet, it is now the only charter signatory to have operative legislation that preemptively defies the courts on a matter of constitutional rights, and the rights of children, for heaven's sake. Now, how did we get here? There are two ways to answer that question. The first is to recount the recent history of legitimized mainstream transphobia, a moral panic grounded in questionable anecdotes and innuendo that has drifted across Canada's border with the United States. South of that border, hundreds of pieces of anti-trans legislation have been introduced or enacted in state legislatures. It's disappointing, to say the least, that a Canadian legislature has followed their lead. That explanation is necessary, but it's not sufficient. The Charter, backed by public support for rights and rights adjudication, was supposed to be a bulwark against precisely this. It was meant to stop anti-minority social sentiment from seeping into our operative law. In Saskatchewan, however, that fail-safe has failed, and the question remains, why? That brings us to the second way to answer the question, which is to consider the populism that has become a dominant strain of political ideology, particularly on the right side of the spectrum. This sort of populism portrays elites and elite institutions, we're standing in one right now, particularly institutions that check the exercise of political power, as corrupt and opposed to the people. We see this anti-elite populism in the rhetoric of the current federal conservative leader, who rails against the ivory tower elites that he claims are, in his words, always telling us how wonderfully sophisticated and cosmopolitan they are and how brilliant they are. This is derisive, disparaging, and deliberately divisive. Sadly, it may prove to be a winning political strategy. And if it does, a federal conservative government may have little trouble justifying the preemptive use of the notwithstanding clause, which Pierre Poilievre has already promised to invoke federally for the first time. Our courts are staffed by powerful elites. We call them judges. Preempting those elites on constitutional questions can be politically viable if, and only if, a sizable segment of the public is persuaded not to care what legal elites think about laws that may limit charter rights. That shift in public opinion is what populist politicians seek to achieve, the deliberate diminution of the political cost of imposing rights-limiting laws notwithstanding the judiciary. That's dangerous. Courts are a counter-majoritarian corrective in a system of constitutionalized rights protections. They're empowered to protect those whom the majority disfavors. And if populists successfully diminish the public respect that courts require to perform this function, then all of us who depend on the Constitution to protect our rights will be more exposed to the intrusive power of the state. In the next and final part of this lecture, I'll explain why anti-elite populism is particularly pernicious in Canada's system of constitutional democracy, and what all of us, especially as members of an elite group called the legal profession, can do about it. Democracy, according to the critic H.L. Mencken, is the theory that the common people know what they want and deserve to get it, good and hard. In Canada, we leaven democracy with constitutional judicial review. And as I noted earlier, we always have, since 1867. A charter case, like any other court-based process, is structured. It's ritualized, right down to the lawyer drag that Sean and I get to wear in the courtroom. In the crucible of the adversarial process, judges, assisted by counsel, strive to get to the truth and to arrive at judgments that are fair and just. To engage in this process, in this adversarial endeavor, requires specialized knowledge and training, which the law students in the room are gaining here at the college, and which their full-time faculty have long since forgotten. It's important work, if for no other reason than we humans have yet to discover a better means of resolving intractable disagreements without resorting to tyranny, violence, or both. But it's also elite work. Court-based adjudication, including rights adjudication, is an elite activity. It's undertaken by elites called lawyers and judges. And the output of this elite activity, particularly in constitutional cases, affects the lives of those who are not members of that legal elite. It affects everybody. When a court strikes a law down as unconstitutional, and that law has majority support in the country, our constitutional system asks the majority to accept the judgment of an elite minority, judges, who declare the law that they support to be out of bounds. This makes the courts vulnerable to backlash. It's why the courts are the least dangerous institutions within otherwise majoritarian systems of government. And history teaches that in fights between popular majorities and judicial elites, majorities win and the courts lose. And minorities, who must depend on judicial elites for their protection, lose most of all. Diefenbaker understood this. He understood it from his time as a lawyer, that politicians are too easily distracted from their moral obligation to uphold rights and freedoms, especially those of minorities, and particularly minorities that are politically unpopular. The Bill of Rights reflects Diefenbaker's experience that if the majority decides which rights are protected and which rights are not, it's the rights of the politically unpopular that are trampled underfoot. In a constitutional democracy like Canada's, we rely on judges to protect us from unchecked majoritarianism. In our system, the work of the courts matters the most when it is the least popular. That is the weak point, the soft underbelly of our constitutional democracy. And that is precisely the point that anti-elite populism deliberately attacks. When a government uses the Notwithstanding clause to impose limits on the rights of a vulnerable minority, and announces that it does not even intend to justify those limits in court, it violates what should be an unbreakable norm, if not a constitutional imperative. That as part of our commitment to constitutional democracy, our shared commitment to constitutional democracy and to the protection of minorities, we subject our laws to scrutiny by an independent, impartial, specially trained elite, namely judges. 40 years ago, this norm lay behind the assumption that using the Notwithstanding clause would require politicians to pay an intolerable political price. Today, as politicians succumb to the allure of anti-elite populism, both the norm and the assumption are slipping away. The vulnerable and the unpopular will pay the price, but so, in the end, will all of us. Here's the good news, though. Populism abjectly follows that which is popular. And political leaders who traffic in populism are not the masters of popularity. They are its servants. In the words of John F. Kennedy's inaugural address, remember that in the past, those who foolishly sought power by riding the back of the tiger, ended up inside. When the charter was before Parliament, Ed Broadbent, then the leader of the NDP, observed, and I quote, "The kind of charter we now have before us will indeed permit legislatures to undermine certain equalities if they wish. So it is mandatory that all of us who concern ourselves with civil liberties keep the pressure on at all times." Broadbent understood that much as the Notwithstanding Clause could imperil our civil liberties, it would also empower us to protect them. He recognized that in our constitutional democracy, it's not ultimately the courts or the politicians who decide which laws operate. We do. Each of us has a burden to exercise that power responsibly, to stand for the rights and freedoms of everyone, especially those whom we do not know, do not like, or do not understand. This is much easier said than done, but it is among our most important responsibilities as citizens. Lawyers have an even weightier obligation. With our education and training, our monopoly on providing legal services, and our membership in the medieval guilds we call law societies, comes the ability and the responsibility to educate and to advocate, to explain to our fellow Canadians what it really means to invoke the Notwithstanding Clause, especially preemptively, and especially at the expense of a vulnerable minority. We have the privilege of bringing cases to court that hold the powerful to account. Through law school clinics and public interest advocacy, each of us can lift up and amplify those who might otherwise be voiceless in our democratic institutions, including the courts. And I submit to you that with these privileges, with our membership in this wonderful and, yes, elite profession, comes the onus to defend constitutional democracy against norm-corroding populism, its mortal enemy. In 1949, Parliament amended the Criminal Code and made it an offense to, I quote, "make, print, publish, distribute, sell, or possess a crime comic," which, as the name suggests, was a type of comic book that graphically depicted crimes. The Canadian press sought comment from the Dean of Law at the University of Saskatchewan, Frederick Clinton Cronkite. He said, and I quote, "It is fantastic that in a democracy there should be any limitation placed on what people read or on their tastes unless there is a clear and present danger to the state. This law concedes that members of Parliament have a monopoly on taste, which is an opinion I do not hold." This lit up the telephone lines. There were calls for Dean Cronkite to be fired. Some folks really disapproved of crime comics, apparently, but Dean Cronkite didn't budge. The university stood by him, and he served 12 more years as dean. You might agree with me about the Notwithstanding Clause. You might not. But whatever your views, whatever the issue about which you're passionate, there may come a time when you must choose between speaking up and standing down, between defiance and acquiescence, between principle and popularity. May you have the courage and conviction to follow Dean Cronkite's example. Thank you.
I'm delighted to say we do have some time for questions, and I know Adam is perfectly identifying hands in the audience, but I'll stand here and if I can. So who would like to ask a question for Mr. Hope? I see it
At the back, yeah, sure.
Good afternoon. My name is Tim.
Hi, Tim.
For the sudden voice burst, that was a little louder than I thought. So you had mentioned several times that we had to, in your speech, leave aside Quebec. Now, Quebec obviously is the jurisdiction that has the most common use of the preemptive use of the Notwithstanding Clause. Currently, I think it's what, Bill 21 and Bill 96 are before the Quebec Court of Appeals right now, probably going to end up at the Supreme Court. Are you watching these cases closely to see how the Quebec Court of Appeal rules the preemptive use of the Notwithstanding Clause?
So the Quebec Court of Appeal has actually already decided the Bill 21 case, and we are watching it closely, and we're going to be talking about it in Regina next week. The Quebec Court of Appeal agreed with the position that the Government of Saskatchewan is taking in our case, which is that once you use the notwithstanding clause preemptively, there's no role for the courts thereafter. We obviously disagree with that, and I'll have several hours of submissions as to why for the Court of Appeal next week. But that is an issue that has arisen in Quebec. The reason I say Quebec is a different case is that, as I mentioned in my remarks, Quebec never signed on to the constitutional bargain in 1982. And so in the early years of the charters being in force, Quebec legislators essentially said, we're opting out of this whole thing. We're going to use the notwithstanding clause preemptively to say these laws are not subjected to review under this federal charter that was approved by all the other provinces and the federal government, the federal parliament, without our assent. And that has been a difference between Quebec's approach and the rest of the country's approach ever since. So that's why Quebec is a bit of an outlier not a bit of an outlier, it's a big outlier when it comes to the preemptive use of the notwithstanding clause. In terms of the effect of the preemptive use of the notwithstanding clause, there was an early challenge to the use of the preemptive use of the notwithstanding clause that was decided by the Supreme Court in a case called Ford and Quebec, in which many read that case as adjudicating the issue of whether the notwithstanding clause can be used preemptively and deciding that it can be. That issue isn't squarely before the Saskatchewan Court of Appeal next week, but it does arise in the Quebec case, and so yes, that will be a very interesting point of law, what the Supreme Court has to say about the Ford decision and whether it is still good law.
Just a quick follow-up. So, of course, you mentioned that Quebec's not a signatory, but the Charter has always applied to Quebec. Every Supreme Court decision has made that clear.
Absolutely.
And the Quebec government stopped doing the preemptive only a few years after, right? It was at 86 or 85 they stopped doing that when the government changed. So I guess what I'm getting to is that the more recent uses should be differentiated from those early uses, and yet it's still being upheld. Wouldn't that be an uphill for you to climb to overcome these decisions and rulings?
It may be. I don't mind climbing hills. The more recent Quebec uses, as you're right, have resumed the use of the notwithstanding clause preemptively after a long period in which that wasn't done. I think that whether that makes a difference legally is an interesting question. I'm not sure I have an answer for you on that in this moment. What I will, though, say is that I commend to you, there's a chapter by Benoit Peltier in the Peter Byro book, to which I mentioned. Peltier was a Quebec politician and a legal academic, a legal scholar, who writes about the respect the Quebecers have for the Charter. And his argument, on which I express no view, is that the reason that Quebecers insist now on using the notwithstanding clause preemptively is not because they don't respect the Charter, but because they do respect the Charter and they recognize that what they want to do cannot be accommodated within it. I still think that doesn't fit with a preemptive use of the notwithstanding clause. That would accord with the justification that a number of scholars have offered for the reactive use of the notwithstanding clause. But I still believe it's a matter of principle. The preemptive use of the notwithstanding clause signals an aversion to court decision-making that's not in keeping with our constitutional traditions.
Thank you very much.
Thank you.
Hi there. I'm wondering, other side. I'm trying to figure out how to say this. So if your argument is anti-elite populism, the central point that you kind of talk to is judges as being that central point. But I think that starts to move away of why they're picking the specific subject. And the subject is trans folks because they have done a very good job of using that as a common enemy to families. And I think while I disagree with it, that idea of inspiring a traditional family is an inspiring portion of what the right-wing movement intends to do. And so I'm giving you that as pre-context to saying, in the next cases that will come inevitably, when Alberta presents theirs, which will be further than the notwithstanding of that's presented in Saskatchewan, or where Pierre Poilievre presents the trans legislation that goes counter to healthcare for all trans adults, they're going to continue to contact the notwithstanding clause to trans individuals. Even if we say that judges are countering that is a way of countering the anti-elite populism. By not thinking about how we expand where our political opinion can bring more people in. Isn't there a danger in doing that, in making the cases trans against parents, trans instead of, say, teachers against parents, instead of, say, professional people against parents, or professionals against the government that are putting them in precarious place, and in terms making a better argument for political opinion. I'm just wondering what you think about the positioning of the legal cases that continue to put trans folks as the central subject matter.
Right. So first of all, I think it's important to say that the framing is no one's against parents. And when we get to the merits of the case in Saskatchewan, which I hope we will, and the case in New Brunswick and the case in Alberta, if and when it comes, that's not going to be the framing. It's medical professionals against parents. Who's against parents are the governments that are trying to deny parents the role that they ought to have in their children's upbringing, which includes raising children who have the autonomy to make decisions for themselves about what is shared with their parents and when they're mature minors or other minors. And those issues are going to be the centerpiece of this litigation eventually. In terms of the attack on trans folks being perpetuated through using the Notwithstanding Clause, what I'm trying to argue in the lecture is that the reason why you go after the judiciary, if you're a populist, is because the judiciary is who stands in the way of that vulnerable minority. And the Supreme Court's recognized in a case called Hansman that trans youth are an especially vulnerable minority in society. The courts are who stands between that vulnerable minority, that regrettably unpopular in this moment minority, and they're unpopular because politicians have made them that way. Trans folks have done nothing to ask for this other than just be themselves. That unpopularity is a vulnerability politically, and the reason we have constitutional rights and courts to protect them is that you can't ultimately trust, or we just don't in our system ultimately trust majorities to protect minority rights. But we should be able to do that. And I think that's the broader point that you're making, which is that I can win all of these cases in court, but if at the end of the day, the hearts and minds of the people who go to the polls on election day are with the folks peddling anti-trans nonsense, and not with the folks who are trying to protect trans kids and the families of those trans kids from interference by the state, then we're going to lose the battle, because the Notwithstanding Clause is a tool in the armaments of the legislatures. And so that political project of making it not just unpopular to set yourself against the judiciary, but also to set yourself against trans folks, against queer folks generally, is the far more important battle than any individual case that I will fight and win or lose in a courtroom.
Okay, hi. So my question just generally relates to politicization of the courts. As in general, I'm sure you're aware of politicization of judicial appointments, particularly in the US, but then also more prominently in Canada recently. So just generally, do you think that recent politicization of these types of judicial appointments, which leads to more politically biased judicial decisions, in the future leads to, I guess, legitimate justification for the use of the clause in the future?
So this is the part of the argument that I find most compelling in favor of using the Notwithstanding Clause, is it's a reaction to unpopular court decisions that's healthier democratically than politicizing the judiciary and trying to stack the bench with judges who are going to decide cases a certain way. I don't agree that we've seen that happen in Canada to any meaningful degree ever. I think there's always a risk of it happening, and it's one of which we should be mindful. But the argument that Professor Newman and Professor Kennedy and others make very eruditely is that if you can use the Notwithstanding Clause to get around a court decision that you think is inconsistent with the broader constitutional commitments of the society, then you don't need to politicize the judiciary, and the judiciary will therefore remain less small p political. And that's a valid argument. My concern is that the use of the Notwithstanding Clause doesn't signal a disagreement with the particular decisions of particular judges, nor do I think it's fair to blame the judiciary for doing its job and interpreting the Constitution that's been put before it. To the extent the argument is that judges should be more discreet or should hold back from interpreting the written document in order to enforce the constitutional rights that are guaranteed in it, that's asking judges to defy their oath of office. And it's not their fault that we've given them this written Bill of Rights that goes all the way back in its tradition to John Diefenbaker's Bill of Rights in 1960. Their responsibility is to say what the law is based on the documents that are in front of them. And so for courts to consider that in their decision making would, to my mind, be dangerous. They have to fearlessly declare what constitutional entitlements are and how the enactments of different legislatures affect those constitutional entitlements, come what may. The danger of the preemptive use of the notwithstanding clause and the rhetoric that backs it up is it takes away the safety that we need our courts to have in order to do that task fearlessly, because it's not popular work. As I said in my comments, the work of the judiciary is most important when it's least popular. And judges need to know that if they do the unpopular thing, the rest of us will have their backs. The rest of us, whether we agree with their decisions or not. And so to the extent that the notwithstanding clause detracts from that and saying, we don't have to have your backs, we don't care what you have to say, that creates a danger not just in the immediate cases where the notwithstanding clause is used, but also in the message that it sends to judges about what will happen if they make decisions that are unpopular, the decisions that we need them to make if minority rights are going to be protected in what is otherwise a majoritarian democratic system.
Hi. So a few months ago, the College of Law had Two-Spirit, McMoggy, Tuma Young come. And so I guess just like when we talk about the constitutional law, then it correlates with Section 35 and then our treaty rights and international laws and our Indigenous laws. So I think if we're using the notwithstanding clause, then we're damaging the relationships with Indigenous people as our identity and self-sovereignty, as well as our education, is protected under those treaty rights. And so it's a huge infringement. And I wonder how that argument can be used within this case, or if it will be.
So it's not part of our case in Saskatchewan. We haven't pleaded Section 35. Section 35, I don't think is pleaded directly in the New Brunswick case, although the Wabanaki Two-Spirit Alliance is intervening in that case, alongside a number of 2S LGBTQI plus organizations. But it's an important point that this idea of the gender binary, there's lots of scholarship to tell us, is not indigenous to these lands. It's something that is a product of colonialism. And to the extent that one can assert an Aboriginal or treaty right under Section 35 to gender identity and expression as a Two-Spirit person, including as a young Two-Spirit person in school, that is an entitlement to which the notwithstanding clause could not apply. So there may be cases, I'm not bringing one of them, but I would be surprised if there weren't, if governments continue down this path, where that entitlement were asserted. But that's not part of what UR Pride is arguing in our case. We're pleading Sections 7, 12, and 15 of the Charter.
Thank you.
I'm going to now just invite my student colleague, Hannah Bouvier, to formally thank Adam Goldenberg for this fascinating lecture.
Just on behalf of the college and the faculty and staff and students, we want to thank you today for taking the time and coming to speak to us. It's been a very good lecture. Thank you so much.
Thank you, Hannah.